Hello, everybody. This is David Warren, co-founder and chairman of Bridgeford Trust Company. Very, very happy to be with you for the next hour, talking about some pretty exciting things happening in the trust industry, a little bit of the past and present and future of where things are going. And it's nostalgic in many ways for me to be with you all today on a webinar sponsored by Macaulay and Asbury, who a lot of you know is a partner of Bridgeford Trust Company and was part of the founding brain trust when we started this company almost 12 years ago, actually longer ago. And the first time Bridgeford ever presented in a webinar format was with Macaulay and Asbury. So in so many ways, doing this today with Macaulay and Asbury and being a part of the Macaulay and Asbury community in central Pennsylvania and beyond brings a lot of pride to those of us who started the company from scratch. And for those of you who remember who Bridgeford was back then, it was really almost just me and a team of people in Pennsylvania and a group in South Dakota that supported our launch. And since Bridgeford has, I'm humbled to say, has grown tremendously. We have now 2 offices in South Dakota. We have a rep office in Miami, a rep office in Southern California, where I am today. You can notice the palm trees behind me. I'm in LA in a conference room, and I guess it's fitting. Wasn't going to sit outside in the sunshine for those of you who are somewhere cold. But the reality is, where we've gone with Bridgeford has been an amazing ride. We've been and continue to be extraordinarily enthusiastic and passionate about the power of modern trust law and how the evolution of that has fueled a whole new industry, really. And we're going to talk about that. And we're going to get into ideas of what we can do now that we couldn't do 10 years ago or 15 years ago. And we're going to really talk about this idea of the new paradigm and what we at Bridgeford support and what so many of you on this call support. And before we really get started too, I see so many names from all over the country of people that have supported us from the very beginning, new friends in California, old friends on the East Coast. And for those of you who supported Bridgeford and have participated in our growth and our brand development, we can't thank you enough. So with that, we will get started. See if I can make sure I get this working correctly. Okay, try this again. There we go. So we're going to start with a polling question, something very exciting. So do you wish to receive CPE for attending today's seminar? And that's how we're going to begin, apparently. And I guess as we wait for everybody to vote. Okay. Well, 63% of you said yes, so that's great. That means there's going to be 3 other polling questions part of this webinar, and please answer them so we can be sure to get you the credit. Okay, so let's begin with this. Legal experts contend that there have been more changes in trust law in the last 20 years that have taken place in the prior 2 centuries. And these changes promise to affect every aspect of how trusts are administered. And that is exactly really the essence of the new paradigm that we're about to talk about. It is remarkable how much change has happened in the trust industry. It's exciting to have watched it over the years, and it's even more exciting to be part of what we call the new paradigm. And so you might be saying, well, David, what do you mean by a new paradigm? And this is what we're talking about. For so many years, the trust industry was defined in such a different way. The old paradigm was a bundled approach. And when I say bundled, I mean asset management and private banking, and in some cases insurance, and all aspects of banking happened in conjunction with trust services. I think of Bank of New York Mellon, I think of Fulton in the Northeast, and in Wells Fargo in the traditional model. And investments were delegated, which meant that really essentially the investment management happened at the bundled big bank approach. which of course was wrought with tremendous conflict of interest. It still is wrought with conflict of interest. And really a lot of that old paradigm big bank model was to capture asset management and not so much focus on trust powers and innovative trust solutions. The old paradigm continues to be where it exists, extremely rigid and expensive, and the complaint is that there's a poor service. So when I was in law school and when I was much younger, before the advent, I would say, of the new paradigm and modern trust law that we're going to talk about, people didn't like working with trust companies. They found them to be hard to work with and inflexible. And at that point too, before modern trust law came along, trust had to end at a certain point, which is really the beginning of modern trust law, which we're going to talk about in a minute. But then along comes a new paradigm, something that we're continue to be really passionate about, which is trust can live forever. It's unbundled. These services are intentionally unbundled, directed, and we're going to talk about what that means in a minute. Very important aspects of trust administration are directed, and powers given back to advisors and families and settlers of trust in ways that didn't happen when I was in law school, and it's changed everything, and it's really the bedrock, I think, of the new paradigm. Conflict of interest in the new paradigm has been almost completely eliminated. And the idea of having to worry about why big bank is telling you to buy a hedge fund has gone away, because those functions are bifurcated. And large families, any family across the country and around the world who wants to maintain control and avoid conflict of interest, this model works. The new model also allows for and invites non-traditional assets like real estate, cryptocurrency, closely held stock. The old paradigm, banks didn't want those assets because they weren't asset management based, which meant they really couldn't charge for those assets. The direction and control we've talked about, we're going to get into that a lot. It's something that I want us to pay attention to together, because it's changed the whole dynamic of how we operate and really who we are in the trust industry. And it opened up the door for trust companies like Bridgeford to emerge in a boutique style that focused on the relationship and true trust administration. And these, I'm using these words intentionally, because at the end, and I want you to stay with me, please, to the end, we're going to talk about a development that's happening not only in the United States, but across the world, where all of that makes the new paradigm so special and makes the trust industry so compelling right now is going back into the old paradigm. And we're going to talk about that, and we're going to talk about how we avoid that as an industry, and how do we make sure we're protecting the integrity of the trust services that large families are entitled to and want and weren't getting out of the old paradigm. And here's where we begin. Surveys of affluent families indicated that they were tired of the inflexibility of the old paradigm, the turnover. I've already mentioned exorbitant fees. The institutional bank-based model was broken. It still is broken, and that's where and why a new paradigm developed, and when we get to the end, why we have to be so vigilant to protect it and to make sure it endures. So modern trust law, quickly, is really defined by a couple of key areas. We're going to talk about a dynasty trust, which I believe is really the beginning of it, asset protection trust, directed trust, which is the bedrock and foundation of all the direction and control delivered back to families, trust protector privacy, and a couple of other concepts of modern trust law that culminate into a really powerful ability to serve families in all these areas while delivering unbelievable direction and control that, again, didn't exist when I was in law school. And I always say the Dynasty Trust, which was born in 1983 in South Dakota, which was the first to abolish the rule against perpetuities. And for my lawyer friends on the line, you're probably smarter than me, that's a very difficult concept to understand in law school. So I was very happy to find out that we didn't have to worry about that in South Dakota when we went there to get our trust charter. But the reality is, all that means is by abolishing this arcane rule against the rule against perpetuities, it allows a trust to live forever and ever and ever. And you all might be thinking, well, who cares? Well, we care because if a trust can live forever, and South Dakota or other states that have abolished the rule against perpetuity doesn't try or say the trust has to end at a certain point, that means the federal government can never force a liquidation or a distribution of the trust assets. And that means then, of course, that you families that are in the 40+% tax bracket aren't going to have to pay that through the state tax. And it's very exciting, and I think the very beginning of the modern trust law world. Every state has a different approach to it. Dynasty trust states are compared, and we're going to show you a comparable, an objective comparable, and so that's important. These modern trust laws are important, but that's not where the conversation ends. We also have to do a mindful and thoughtful comparison among top-tier jurisdictions in terms of what's really the best options for clients, and we will get there. State trust taxation. This is the power of the proper trust situs selection, the vital importance of it. That's another theme that we're going to talk about. It's something that Bridgeford became so wildly interested in when we launched the company. You know, it's the selection and the decision and the idea of creating a trust is important. But now more than ever, where to put that trust? Is it South Dakota? Is it Cook's Island? It matters. Is it New Jersey? It shouldn't be in most cases. California, absolutely not. And we're going to talk about why. Because first of all, taxation matters, and state taxation is distinguishable. States like South Dakota do not have a state income tax, which means that a trust properly established in a jurisdiction like Nevada or South Dakota or Delaware, there are mechanisms to avoid taxation on assets inside of the trust. And it isn't just a cocktail party discussion that you talk about with friends. It actually is something that's supported by a Supreme Court case called Cautionary, which is one of the first tax cases that's come out of the Supreme Court in, I don't know, 30, 40 years. And it was so amazing for the trust industry because it confirmed and affirmed the idea that if a trust is properly established in a jurisdiction like South Dakota, Pennsylvania cannot tax the undistributed income. California cannot tax undistributed income. For families, especially large trusts, that is a real number that you're able to save over multiple generations, because I've already told you that we also can keep these trusts alive and impenetrable literally forever. And along with the idea of state income tax, there's something called an ING, an incomplete non-grantor trust. It's a very clever tool to deal with closely held stock or any sort of asset that has a very low cost basis. It's in the news a lot lately because this incomplete non-grantor trust was recently just abolished in California, and that's why we're here this week, because my friend and I, Bill Lipkin, did two presentations, one in LA and one in Orange County, explaining to California residents that while the incomplete non-grantor trust strategy, and for those of you who would like more information on it, of course, please contact me offline, that although that has been abolished in California, all is not lost. But for sure, it still works in states like Illinois, New Jersey, and other high income states or high income state tax. So, I mean, the reality is there are really important reasons to be looking at state taxation and understanding why the jurisdiction selection is just so vitally important. Another amazing tool is something called a community property trust. Again, we can get into that in more detail offline. It's just another way of saying to my friends across the country and around the world that are on this webinar, jurisdiction matters, and particularly in this genre of jurisdiction matters. You can measure if we've chosen the wrong jurisdiction with dollars here, and we're going to get into a really important question later, and so keep that in mind. If we know, because I'm telling you, and because legal experts have told us, and we now have Supreme Court cases that support it, that if you choose a proper trust jurisdiction, you can avoid a significant state taxation and potentially federal taxation forever. And somebody didn't tell you that, well, you know, we can measure those damages, can't we? So we're going to get into really the question as to whether or not there's even a fiduciary duty to have this conversation, and I'm going to explain why I think there is one. But before we get there, we'll talk a little bit more about some of these modern trust laws. And I've already made this point, just by simply selecting a proper trust jurisdiction, there's a tremendous opportunity to save on taxes. This is not a tax scheme. This isn't tax avoidance. This is following the rules. This is not something that, I mean, I meant to say tax evasion. It is tax avoidance, but it's legal tax avoidance. This is not tax evasion. That's not what we do at Bridgeford. That's not what the experts on this call do. And I need to make that distinction, particularly because of this point. And it's a theme that I've been noticing around the last 2 or 3 years, probably really highlighted by the Pandora Papers, for those of you who know what that is. You know, our industry, those of us who get excited about big ideas and work with large families to put them in the right trust jurisdiction to give them asset protection and privacy, which we'll talk about in a minute, and the state taxation that I just went through, you know, I mean, we've been sort of attacked in the media as somehow aiding and abetting nefarious human beings, and that's in families, and that's not at all what we're doing. I think what we're doing at Bridgeford and what so many of you on this call are doing is actually virtuous. I think that we're delivering solutions. We're allowed to find the best tax solution for our families. We're allowed to have asset protection. I think it's a right in many respects, especially that and privacy. And so when the media, particularly certain publications out of London, attack jurisdictions like South Dakota and companies like Bridgeford, I become offended by that, because I think what we're doing collectively as an industry is virtuous. I'm proud of it, and I think everybody on this call should be proud of being part of it in some way or another. And I think it's something that, I mean, I don't think we should have to defend ourselves. Which brings me to asset protection, because it's interesting. I've been advised by people to not use the phrase asset protection, because those two words, three, I guess, asset protection, trust, sort of denote nefarious behavior by definition. If somebody wants asset protection, well, they must have done something wrong, is somehow the presumption, which is false and not accurate. Again, I think we're all entitled to asset protection in some form or another. For those of you who have been in this industry for a long time and saw the movie The Firm, we remember that the only real way to get asset protection was to go to Cook's Island or Bahamas or some other offshore trust jurisdiction, which has changed, and we'll talk about why that's not necessarily the preferable answer anymore for asset protection. But you know, many years ago, not many years ago, I would say now 30 years ago, states like South Dakota and Alaska and Delaware created what is called a domestic asset protection trust. And you know, there's a lot of debate about whether these actually work, and I'm going to explain to you why they do in a minute. But I want to define it because it's an interesting opportunity to plan for your family. It's self-settled, which means, you know, myself, David Warren, can set up a trust and be the beneficiary of the trust, and that's why it's called self-settled. It means I have access to income. It means through something called a directed trust, which I'm going to explain to you in a couple minutes, I and my family maintain tremendous control. I also have a discretionary beneficiary interest too, which means I can go and ask the trustee for money if I need it. And that is powerful. So basically, I'm taking assets out of my direct control, putting it in an asset protection trust in South Dakota or Nevada. I still have access, I still have control, but you know what I have now also is protection. And not all states have this codified. Most states do not. Top tier trust jurisdictions consistently, year over year, has been South Dakota, Nevada, Alaska, and Delaware. Delaware is slipping a bit, and I'll talk about why, just because they're not really keeping up, though, with states like South Dakota and Nevada. But as I've said, what this delivers to the market is the ability to protect your assets while maintaining control, while making sure that we are insulating ourselves as much as we can. And you might be saying, well, David, what does it protect us from? And it protects you from creditor claims. It protects you from, you know, especially for business owners. And I'm a business owner, of course, at Bridgeford. We're always a target. Doctors are targets. And what this allows you to do is have this protection, again, while not handing it over completely to a trust company and losing control. I talked about how a handful of states have these statutes. I mentioned earlier, you know, the devil's always in the details. So just because a state has an asset protection statute doesn't mean it's the best. Trust in Estates magazine, as in the previous slide, said the 4 jurisdictions I mentioned are the most powerful, and they certainly are. I would argue for various reasons, perhaps South Dakota is the strongest, and I'm going to get to why in a minute. But one of the things we have to compare when you're talking about asset protection with your families and your clients is, you know, fraudulent conveyance, which is essentially look back. You know, Delaware's 4 years. Excuse me. Delaware's 4 years. South Dakota's 2 years. Wyoming, I only mentioned because it's 4 years, but for some reason everybody's talking about Wyoming, although nobody in the trust industry has identified them as a top tier trust jurisdiction. So we'll talk about that in a minute. And we talk about how to use these. You know, I'm not going to get into the particular details here for us, but we can use these in conjunction, or rather in lieu of a prenuptial agreement. For those of you on the call that work in the family law space and asset protection, prenups don't always work. Prenups have a lot of requirements. So we have seen, particularly in Pennsylvania, but also all over the Northeast and now in California, families using domestic asset protection trusts because they don't have to be revealed, they don't have to be disclosed. We'll talk about the privacy provisions in a minute. I mean, this is powerful stuff, using domestic asset protection. And so I alluded to earlier, you know, this idea, well, some people say they don't work. And let me explain that before we talk about the Cleopatra case. There are those that don't believe domestic asset protection ultimately is going to work in the final analysis and in the final hour. They claim in large part through hyperbole that courts aren't going to honor other state edicts in terms of South Dakota, for example, which I'm going to get to in a moment. And despite the interesting how many angels could dance on the head of a pin discussion at a heckling conference, there is no case in the United States that has pierced an asset protection trust because the statute was considered to be wrong or otherwise not enforceable. The only cases we have that's ever pierced a domestic asset protection trust had to do with a fraudulent conveyance, which essentially meant that somebody set up a trust after knowing they were going to owe somebody money. We don't want that. We don't want to encourage that. That's not what we do at Bridgeford. That's not what the industry stands for and promotes. So getting back to why I would say maybe at the moment South Dakota is the strongest. The South Dakota Supreme Court, in really a blistering opinion, unequivocally refused to enforce a California creditor order from a California court. It came out of a divorce. There's a domestic asset protection trust. They came into California, they came into South Dakota court and, of course, asked the court or otherwise told the court to direct the trust company to pay, and the court not only didn't give them the order, but gave us in the trust industry an amazing case to rely on to say, look, this works. And it all turns on the spendthrift provision and the nuances that the perception and the reality is that the beneficiaries and the settlor in this case did not have unbridled control. And I'm happy to talk offline more about what all that means, but for purposes of today, it's another arrow in the quiver of the modern trust law world that we haven't celebrated. Bridgeford Trust Company is this idea of asset protection that didn't exist, and it's very much part of the new paradigm. Which brings us to our next polling question. Domestic asset protection statutes have been shot down by U.S. courts. So what do you think? Hopefully, if you guys heard what I said 30 seconds ago, this is an easy question. And as you're voting and as we're waiting for the tally, I have to tell you, asset protection in the United States has become so compelling that, and nobody likes this dirty word, but the United States is now considered by the New York Times and national and international media as a privacy and asset protection haven. And that's a reason, that's a symptom, I guess I'll say, of international reporting regimes that have really scared large families from all over the world out of countries like Mexico, out of Switzerland, in fact, and out of other traditional privacy and asset protection havens right back into the United States. And it's exciting to see it. I've watched it unfold in the last 12 to 15 years at Bridgeford, and we see the United States and South Dakota in particular being of use to families who really need and want this kind of protection. So far, we've talked about the advantage and the importance of the advantage and the importance of selecting proper trust jurisdiction, and this is just another example. And I'm really happy to see the answer was what I was hoping I was going to see. And so again, as we continue down the road of the conversation of modern trust law supported by the new paradigm, now let's talk about, as I mentioned a few times, the very foundation and bedrock of the new paradigm and of the new world, and why I and my partners, along with Macaulay and Asbury, became so excited. And here's the quote. And actually, this was almost a guiding light quote from me, because I found this as we were launching Bridgeford. It was one of the first articles I pulled when we decided to do this. I used it as research to convince my partners to do this in the first place. And here it is. The emergence of upstart, non-depository, public-directed trust companies is a disruptive force to be reckoned with. That was written and published in 2012. 2023, it couldn't be more true. And it's the driver of modern trust law, in my view, and it is what has opened the door to companies like Bridgeford to really change the world in the trust space. So let's talk about what a directed trust is and what it means and why it matters and should matter to you and your clients. And here's the quick summary before getting into the details. What this does, the directed trust, is deliver direction and control right back to settlors of trust, their families, and the advisors that they serve, rendering trusts no longer scary and malleable. the legal construct is that it just bifurcates liability, and that's kind of a fancy way of saying that it changes who's responsible for what. It unbundles functions like asset management and trust services, and it indicates that a company like Bridgeford is legally responsible for what it does on the trust administrative side. And then it says companies like Morgan Stanley and others that manage money, they're responsible for what they do. Bifurcates liability. You all may be sitting back scratching your head saying, well, who cares? Well, here's why we care. When a company like Bridgeford is not worried about being sued because an asset manager put everything into Bitcoin, that changes the narrative and it changes the options for families. What I mean by that is it allows families to work with whomever they want to work with. They don't have to go to Bank of New York Mellon and then have to adhere to a Bank of New York Mellon tells them to invest in. They don't have to do that anymore. They can choose a company like Bridgeford and use any asset manager on the planet they want to. And it's their direction, and the liability is bifurcated such that it allows Bridgeford to be willing to do that. And it also allows asset managers to be willing to do that too, because they're not responsible for the actions of the trust company. And on its face, you may say, I don't know why that's so revolutionary. It's changed the conversation, the narrative, and everything that we do in the trust industry, because when you think about it, nobody wants to be told what to do. And that's where the trust industry has been broken, because large families would go to Bank of New York Mellon or wherever, and you name it, the big bank, and they were told what to do. They couldn't change the trusts. They couldn't give any direction in terms of investment management. And that's why, and of course, we mentioned they were so expensive. So then all of a sudden, these families are saying, okay, you know what? I'm not going to use a Bank of New York Mellon. I'm going to appoint Uncle Bob to be my trustee because he's going to do what I tell him to do. And while that solves the problem for them in the old paradigm, it creates a whole panoply of other problems that we've written about on our website. That I mean, an individual trustee is, in my view, never the way to go. I don't say that because I own a trust company. I say that because being a trustee is serious and takes a lot of work. And you know, a broken trust industry made individual trustees emerge as the solution of choice. The pendulum swinging back in the other direction because of the directed trust. And that's a good development. I think it's positive. It's the new paradigm. I'm going to say that over and over again. And it's a paradigm that just needs to be protected. Simply, this is the schematic of how the directed trust works. There's nothing particularly sexy about it. You just see you have the trust at the top. You have various committees that have fiduciary power to make decisions and direct the trust company. The administrative trustee is, we would like it to be Bridgeford for all of you. And you can see what the responsibilities are. But I think if we pause for a moment and realize just how exciting and really revolutionary this is in our industry, you know, I don't like phrases that everybody uses, you know, game changer, and you know, we use the word amazing too much too, but this is amazing and it's a game changer. I mean, it really has changed the entire climate, or not climate, but landscape of how we operate, how we interact with our clients, how advisors work together. I mean, imagine a world where advisors aren't competing with one another to serve clients. This is what this creates. You know, the asset manager and the trust company were friends. We're not competing. I'm not trying to manage money and they're not trying to be a trust company. We all get along, and guess who benefits? Family, the client, because they get all this control back. And oh, by the way, it's a cheaper model too, which isn't always, you know, the most important conversation, but it's a cheaper model and it works. And we've been so proud to be a part of it. I think almost as equally revolutionary as the directed trust has been in our industry, the trust protector. This is a European concept. Every time I'm in Europe and working with international families, they know what a protector is. It took the United States a long time to catch up, but here we are, and I'm proud that we have it. You see, we call it a super trustee. And again, you might be scratching your head and saying, why do I care about this? Well, it's another mechanism of control for you and your family. You appoint somebody in this position, or your client does, that is going to effectively do what they want and carry out their wishes. And used in conjunction with the directed trust, it's extraordinarily powerful because the power that's granted to the trust protector is almost limitless. And particularly in South Dakota, there are 23, I think, different powers you can give. You don't have to give them all, but you have the ability to give them those powers, the trust protector those powers. And it's simple things that they can replace the trustee. They can change trust situs with a stroke of a pen. They can replace the asset manager. They can direct distributions. I mean, it's an enormous amount of power. And so these are the reasons why we want to think about it. You know, the settlor doesn't want to give up control. I don't want to give up control. You know, advisors don't want to give up control. And that's why the old model is just so broken, because you have say you have a $1 billion family who needs these different aspects of trust planning and legacy planning, but in order to get it, they have to hand it all the control over to a big bank where turnover is awful and fees are out of control and it's highly institutionalized. And oh, by the way, the conflict of interest is rampant. You know, I mean, this isn't, it sounds like I'm maybe a bit preachy on it, but I've seen it firsthand. I practiced law for years. In that capacity, I saw the conflict of interest. And then I went into the trust world and I saw it even more so. I was slapped in the face with it a few times, and I'm not going to mention the companies I was with where I saw it. And I couldn't believe the industry tolerated it. I couldn't believe large families tolerated it. But guess what? The large families didn't ultimately, because it's the largest families in the country that have pushed the agenda on these modern trust laws. You know, some of the largest families in the country and in the world went to South Dakota, and South Dakota heard the cry and created a dynasty trust, and then created a directed trust, and then brought asset protection. This is a market correction. The new paradigm is an absolute market correction, which I love to see, driven by the market and people who just looked at the big bank model and the institutionalized conglomerate and said, nope, not working for me. We're gonna create a new paradigm, and that's what we embody, and that's what we're protecting. So I wanted to spend a little bit of time on privacy, because again, I think it's part of the modern trust law world and tools. And I also want to be clear about what we're talking about. We're not talking about secrecy. And this is another quote that I love. I don't have to read it to you, but it basically is telling us that, you know, privacy is what we're after, not secrecy. Secrecy was Switzerland, which meant they were hiding from the government and hiding tax reporting and that sort of thing. That's not what we advocate at Bridgeford. We talk about privacy. We talk about, in my view, a right that we all have to privacy. You know, not so much hiding from the government, but keeping information out of the public domain. Those are two different concepts. And I'll say it again, I'm not advocating, we're not advocating hiding information from the US government and not filing your taxes. What I'm saying is there are aspects about our lives, though, that may not be and are not the business of the government, and in particular are not the business of the public domain. And here's what I mean by that. And it's very simple, and I'm going to be very honest as I say this, because this is true and has been said by people far smarter than me. Unequivocally, hands down, South Dakota has the strongest and most powerful privacy provisions in the country, so much so that it's driving families from all over the world who are worried about privacy concerns into South Dakota. Families from Mexico, all across Latin America, Europe. And it's really interesting to see, and I mentioned earlier that big scary word haven. Well, that's one of the reasons why we're called a privacy haven, and in particular, it's South Dakota. And no surprise, South Dakota has been attacked a little bit in the media. And it's been called the little Switzerland, and you know, these publications through the Pandora Papers tried to suggest that, again, I used the word nefarious, that all of us who are helping wealthy people follow the rules, protect their assets, do tax planning, and have some modicum of privacy. Somehow we're the bad guys and we're the bad girls and we're the problem. And we are not the problem, we're the solution, and I say that proudly. So breaking it down, what's this mean in South Dakota? Why am I so excited about it? There are two quick aspects to it, and it isn't complicated. One is a court seal. You know, I used to do fiduciary litigation. I saw this happen all the time in Pennsylvania. If a trust finds itself being sued by a beneficiary or in litigation at all, it all becomes part of the public domain. And you say, well, David, what do you mean all? Names of the beneficiaries, names of the settlors, names of the asset managers, in some cases, what's in the trust. All that information is open to the public through the docket system, through hyperlinks, and it's alarming to families. Not so in South Dakota. It is so in California, but it's not so in South Dakota. And it's the only state that has an absolute court seal without having to go to a court to get it. It happens immediately, meaning that none of that information will ever get into the domain in the hopefully unlikely event of an actual lawsuit. And it happens forever in South Dakota. It's forever in Delaware. It's only 3 years. In Delaware, you have to go beg a judge to give it to you. And we all know judges don't always give you what you ask for. So that's the other, as we're rounding out the power of modern trust law, that's another aspect of again, the new paradigm. You know, this privacy conversation is paramount, and again, I believe a right to something that we all should have to protect our information. Well, you know, I should go back, because there's another aspect of this that I missed, which actually may be more important to all of you, and I know it is more important to international families because I've heard about it as recent as a couple weeks ago when I was in Mexico City. Under South Dakota law, you can have what is called a quiet trust, which means that the settlor of the trust has the power through the document to tell the settlor and the trust protector to tell the trustee, Bridgeford, not to tell anybody about the existence of the trust, including beneficiaries. And again, you may be asking yourself, why do I care about that, David? Well, here's why we care. You have a son or daughter that's at Harvard and they're in their second year, and all of a sudden they start getting statements from Bank of New York Mellon informing them of the fact that at some point they're going to have access to $100 million. And that is not something a lot of families want their kids to know, because they want their kids to go back to school in the fall, and they don't want their kids to get soft and lazy and think they're going to have an entitled, beautiful life. They want their kids to work for it. We all have read, or if you haven't, you're aware of this idea of what happens over generational transfer of wealth and the danger and destruction it has on families and third, fourth generations. In fact, statistically, third, fourth generation squanders all the money. So this is a way for families to control the information, and families love it, and it works, and it's powerful, and it's something that we're really proud to do. I think the last modern trust law, before we kind of go into the direction of where is the future of all of this, is a purpose trust. You know, we think of the concept of a charitable remainder trust or a charitable trust. And what is that purpose? That purpose is to benefit a concept, an idea, a cause. And it only existed in the charitable space for a very long time. And then along comes South Dakota and some other states creating the purpose trust. And I always joke, what is the purpose of a purpose trust? Well, it's to not have a specific beneficiary. It can have a charitable intent, but it doesn't have to. It could be for the benefit of, and it's not a tax move. It doesn't have anything to do with doing this for tax purposes. You can set up a trust to care for, you know, the Doberman pinchers in Iowa. That's the cause, that's the purpose. You can set it up for any myriad of ideas and concepts and big ideas that you like, and it operates very, very well because it brings what? It brings asset protection, what I've already talked about. It brings privacy, and it does bring those tax benefits I already talked about from at the state and federal level, and it really opens up the ability to use trusts in creative ways. We see them a lot in the private trust company space. We see it a lot in real estate. We see recently we're doing more and more work with celebrities in California. So this is perfect for royalties and holding royalties, or using that as the purpose to disseminate the royalty payment, cryptocurrency, and you see some others. Cryogenics is something I have to mention just because I still can't even believe we're involved in this, but I'm proud to be. Many years ago, for those of you who don't know what cryogenics is, think of Disney on Ice. And I'm not talking about the show. I'm talking about Walt Disney, who believed in cryogenics and believed that by putting himself in some sort of a deep freeze, he can be brought back to life when his particular ailment that killed him has a solution, has a treatment and a cure. And so, you know, regardless of what we may or may not think about this from a religious perspective or from an ethical perspective or a lunacy perspective, I guess, lots of people believe in this, and I believe in it if that's what they think they want. And we at Bridgeford we hold some of these. And when you say, what are we holding? You know, we ultimately will hold the asset of the body that will hopefully be brought back, or at least that's the purpose of the trust. The purpose of the trust is to exist to fund and take care of this person that is, in their view, brought back to life. So, you know, removing sort of the salacious idea of the concept, it makes the point of what is a purpose trust. Again, another aspect of modern trust law that we're excited about and we endorse. And here we go to the next polling question. Under modern trust law, irrevocable trusts are rigid, generally, and generally still hard to deal with in the planning process for families. True or false? So as you're taking time to think through that, you know, the directed trust model is amazing, and it works. And you have companies like Bridgeford that grew up in that vein. But it's not to suggest that there's not a place for a discretionary trust. And I want to define that carefully, because discretionary is part of the old paradigm, but not always bad. Meaning that the trust company has full authority over asset management, who to select. When I say authority, I mean liability. That's really what I'm talking about. Same thing with distributions. When you're looking at the new paradigm world, and you want a trust company to do one of those two functions, and what I'm saying is make discretionary distributions or make discretionary investment decisions, Bridgeford still does that. We still operate like a traditional trust company, but we embrace and really move towards the new paradigm, and we consistently recommend the directed trust so families can maintain the control that we've been talking about, and so families can get to have access to the new paradigm. And thank you for those of you who answered that question correctly. And we'll move forward here. Hold on. There we go. Let me take this back. Oh, I guess we did that. Okay, so very briefly, you might be saying, well, David, this is all great, but I have a trust that's 500 years old or 200 years old or whatever, and how do I get this? How do I breathe new life into these trusts? How do I get a trust in the South Dakota? How do I get a trust to be directed? How do I bring asset protection? How do I get all these amazing things, David, that you've been talking about for the last 40 minutes? And here's the answer. It's called decanting. It's another wave that hit the trust industry that I think is revolutionary and urgent. This is another one. You essentially can pour assets without a tax consequence into a new trust. Decanting, you think of wine, of course. I think of it too quickly sometimes, but you think of decanting, and that's the idea. You can get access to all of these modern trust laws with existing trusts without having to go to court and without having to go through the hassle. And so when to use decanting, you can see that you don't need me to read this to you, but we see it most particularly in moving trust situs and adding modern trust laws like I've been talking about. Or changing aspects of trustee powers, and just generally, as I said a moment ago, just breathing brand new life into a trust. That's the power of it. Not all states have a statute, I should say. I can tell you, New York was the first to have it. South Dakota, for 8 or 9 years in a row, has been determined to be and have the most flexible decanting statute in the United States, and that was determined, and I expect it to continue to be determined by the same outstanding Nevada attorney. And I only chuckle because, I love his credibility. He's a Nevada attorney, which is a great trust jurisdiction that says that South Dakota has the best decanting statute. So this is part of the tool chest I mentioned, the arrow and the quiver, whatever analogy you want to use, which gets to a really interesting case. And this is going to start a theme that we're going to talk about, and we're going to kind of lead through a theme that takes us to what's happening in a negative way in the trust industry right now. But this idea is there a duty to decant, right? So I just told you there's modern trust law. I just talked about all these things that happen in the new paradigm, and then I just told you, well, there's a tool to get it, right? There's a way to get there if you want it. And the Massachusetts Supreme Court raised the question, well, if we know that our job as a trustee is to protect these assets, privacy, all the things that we're talking about. If we know that, and we as trustees, or more broadly, we as advisors don't advise the client, hey, get this trust out of Massachusetts because the assets could be attacked or they're going to be taxed. We know that. So that's in and of itself compelling enough to move. And the court asked the question, is there a fiduciary duty to move the trust? Think about that question for a second. I mean, is a Massachusetts trust company going to remove revenue from its own company and send it to South Dakota? Of course not. Well, wait a minute. Isn't that a conflict of interest? Of course it is. So this is where we're starting to ask these important questions in our industry, and this brings me to another, I guess I'll say, seminal quote that was a guiding light for Bridgeford, is this idea of, and I said it earlier, the choice of a state in which to establish a trust is as critical as a decision to create one in the first place. Choosing correct jurisdiction is so important right now, and we're gonna get to why it's even perhaps more important than we realize. I mean, I raised the specter that this Massachusetts Supreme Court said duty to decant. Keep that in mind. Think about everything that we talked about in the old paradigm, conflicts of interest, all of these things. If we know we have solutions, do we have an obligation to bring them to our clients? Hold that question, because I'm gonna show you some statutory authority that says we do. But this trust situs selection is paramount. So I've already said that there's 4 considered to be top tier. That's by Trust and Estates magazine year over year. South Dakota, you could read them. Nevada, Alaska, Delaware is still considered top tier, but especially for my friends on the East Coast who may have an East Coast bias with Delaware, I'm not speaking out of turn by saying, and even Trust in the States magazine said itself, Delaware is just not keeping up. It's not as progressive. I think unequivocally Nevada and South Dakota are considered to be significantly more progressive at this point. And I'm not suggesting rather Delaware's a bad jurisdiction. I'm just suggesting there's better jurisdictions out there, and I think advisors are starting to come to that. I put Wyoming as a question mark. I have to give them credit. They've created a lot of noise about what they're doing in Wyoming, but still not the top tier trust jurisdiction. It's funny when I run into them when in a competitive situation. I don't know how they got so much attention onto the state and their trust laws, because they're not as progressive as South Dakota's, Nevada's, Delaware's, and the other top tier trust jurisdictions. And even if there are people on this call that enjoy and really like Delaware and use them heavily, that's fine. And I'm not criticizing the decision, because it's not a terrible jurisdiction. I just think there are better, and that we have to keep that in mind. The polling question, I think it's the last one. Which of the following is considered a top tier trust jurisdiction? And choose carefully. So as you're going through this, the emergence of this race to be the top tier trust jurisdiction has really been fascinating to watch. And I get the question all the time, well, why South Dakota, why, or Nevada, why do these states care? Here's the answer, and I have to give credit, of course, to South Dakota, not just because it's where our trust company is, but because they're pretty innovative. It isn't just a flyover state. There's some extraordinarily brilliant people in that state, and before they were the first to abolish the rule against perpetuities, they were the first to abolish excise tax on credit cards, usury tax on credit cards, which drove the biggest credit card companies on the planet into Sioux Falls, South Dakota, and other areas in South Dakota, so they can avail themselves of that state law. And what that did was created an unbelievable industry. I mean, if those of you on this call have not been to Sioux Falls, I encourage you to go. It's an amazing little town with tremendous wealth. And South Dakota knew what it was doing back in the 70s and 80s, and carved out a niche for itself. And that's, again, in my mind, pretty brilliant, and something we have run to and embraced over the years and really love. So I'm not going to go through in particular detail of the charts, just to say that it exists. We put this together over the last 10 years at least, and it's a very detailed consideration of top tier trust jurisdictions, sort of point by point, compares what Trust in the States magazine says about comparative data. It takes some very, well, you could see the citations down there. There's lots of data point areas that we considered to put this chart together that unequivocally kind of shows, of the top tier trust jurisdictions, which one or two are at the top. And I would argue it's Nevada and South Dakota, and I would also argue there's aspects of South Dakota that make it preferable, and I think more and more people are seeing that. And the chart is meant to be objective. It's not to be salesy. My last comment was not meant to be salesy. My friends may be thinking on the call that's very self-serving for me to say what I just say, but I say it because I believe it. Advisors from all over the world believe it. That there are aspects and nuances of South Dakota law that makes it the jurisdiction of choice for so many people. So here's where we're going to go in the last couple of minutes here before we take some questions, if there are some. This idea I mentioned about, is there a duty to decant? Well, let's expand it. And I'm going to put a fine point to it at the question at the top. Is there a fiduciary duty to create a trust or move trust into a top tier trust jurisdiction? Well, I've already told you now, since we started, that there's all these bells and whistles that are available just by going into the right trust jurisdiction. And I alluded to earlier that, in fact, now we can even measure what happens if you don't do it. If your trust is paying 13% tax on undistributed income in California because your lawyer didn't say go to Nevada or South Dakota to avoid that, well, that's a number that could be used in a scary, you say the scary word, malpractice case, right? Why is that not malpractice at this point? We know these laws exist. The answer can't be, well, I don't know, I'm a South Dakota attorney. Well, you need to know that these things are available, because people know that Delaware has strong LLC laws and they incorporate in Delaware. It's the same analogy. So if we know that, but we don't know that being in South Dakota or Nevada saves money and gives you asset protection and gives you things that California doesn't, then I think we're looking at a problem. And it's not just me saying that. There are various ways that are being looked at. I mean, various statutory authority, things that, seminal works that guide the trust industry. I'm not going to read all of this to you, but there's a uniform probate code, which most states have adopted. There's language that says that there is a fiduciary duty to protect the assets and to find essentially the right place for it. That's one data point. Restatement of thirds says it in multiple places, including comments. Fiduciary duty, yeah, we have to protect these assets. We need to make sure that the trusts are properly not just administered, but have the right attributes. And I extrapolate that to mean putting it in the right trust jurisdiction. I mentioned already the comments. I mean, it really is all over the place on these kinds of things that I read in law school, that guide lawyers, guide the trust profession, and that create the foundation of how we all operate. And the theme is consistent. There's also something called Scots on Trust that is also saying the same thing. So again, do I sound too salesy and self-serving? Perhaps, but it's a question that we have to wrestle with, because families deserve better. Families deserve to have advice given to them that is not wrought with conflict, that is well thought out, and that puts them in the best possible protective position relative to all aspects of their life. And this is where we're going to conclude, because as we advertise, I'm concerned about a development in the trust industry, and I think we all should be. And here is what we accomplished with the new paradigm. And then I'm going to talk to you about how the new paradigm is under attack now. The trust industry is undergoing a quiet revolution that has wrestled control of trust accounts away from traditional trustees, i.e. the old paradigm. Banks are in the hands of banks and other large institutions. I'll say institutionalized institutions. And they're bringing them into the hands of trust companies like Bridgeford and like boutique trust companies all over the country. Well, guess what? That happens. And that was also 12 years ago. And 12 years later, that is more true than ever. I mean, Bridgeford it looks after multiple billions of dollars that have come from big banks from all over the world, okay? Because this model works. And so here's what happened. When the industry sees a model work, they want to replicate it. And so what we're seeing is very institutionalized international conglomerates coming into the United States, obtaining trust powers in states like South Dakota, opening South Dakota trust companies, another division of their big behemoth, and operating in the jurisdiction. Often these are private equity based. South Dakota saw the sale of its biggest trust company at the time in the last 6 months by a gigantic international conglomerate, and that changed the industry for sure. Got a lot of people's attention, and now renders Bridgeford one of the largest, if not the largest and oldest independently held, privately held boutique trust company in South Dakota, which is amazing on so many different levels. The problem with this new model, in addition to everything else I'm going to get to, is that often they see the money grab opportunity. They want to stop the money leaving. When I say they, I'm talking very large institutional companies. They want to take part. They want a piece of the action. And this is more of a problem for international trust companies. They come into states like Nevada and South Dakota, and they don't know how to administer trust properly because they're doing it under Jersey. I won't mean New Jersey. I mean Jersey, Guernsey. Different. They do it in a different model that's not consistent with U.S. requirements and regulation. And I can tell you, regulators all over the United States are just alarmed at these companies have come in and these companies, some of them have gotten in trouble, and they're coming in and they're buying the boutiques. They're buying the Bridgefords of the world who actually created themselves to solve a problem, right? We started old paradigm is a problem. Bridgeford, new paradigm solves that problem. All of a sudden now we're going back towards the old paradigm. The big bloated conglomerates are coming in and saying, oh no, we can do this. Now we're seeing the return of conflict of interest. Now we're seeing the boutique nature of all of this is going away. And this pendulum's going back in the other direction, and it's alarming. Not all things are about making money. I mean, the trust business is a relationship business. So is the asset management business. And what we have seen in the last 20 years, 25, 30 years of the new paradigm is large families are saying, no, I don't want to be part of a conglomerate. I want individualized service. And I want to be able to pick up the phone and call my trust office and have them answer. And I want my trust officer to be there and not only work their 2 years and go to another trust company. These are all things that the new paradigm solved. They want the ability to have direction and control. And probably most important, they don't want to have to deal with conflicts of interest anymore, because that's the problem. And so those of us who created ourselves in the new image of the new paradigm, who decide to sell ourselves to, the JTCs of the world or these private equity backed organizations, we're basically becoming the problem that we created ourselves to solve. And that's not okay. I think it's not good for the US trust industry at all. I don't think it's good for the families at all. And I think it's something that we need to protect. I think the integrity of the independent model created and emerged for a reason. I said earlier, it was a market-driven response by families who had had it with the traditional conflict-ridden model that they didn't have any control over. And so that's when we're talking about the past, present, and future. Bridgeford is wildly independent, as are other companies like ours in the United States, and it's our commitment to remain so, because that's what our clients have told us they want, and we're looking to build in that image for multiple generations, as far as I'm concerned, at Bridgeford. I can't speak for others, and the idea was never to become part of an international conglomerate or any kind of conglomerate, because that's why we wanted to build Bridgeford in the first place, to not be that. So I'm going to go to a different screen to see if there are questions. But before we get there, I want to thank you all very much. And for those of you here with me, it's amazing to be able to talk about these concepts with all of you, because these are concepts that, these are concepts that have happened in our industry that has changed the world in many respects. So I'm looking to see. I might not be in the right screen here, but I'll keep looking. Okay. Oh, here we go. I found them. Sorry. Okay. All right. Let's see about the time here. I think I have time for this. This is what kind of faculties a trust protector should have with respect to the trust. And it says, thank you for the webinar. So I think really the question there is maybe talking about the powers of the trust protector and what should be given to the trust protector. And as I had mentioned before, South Dakota has 23 different powers you can give. I'm happy to send anybody and you for this question a copy of the statute that outlines it. But the key though is that you don't have to give them all the powers. And so I think it's very situational. I think it's a matter of looking at how much control you want to have, and then making sure you have the right person. And a follow-up question to that is, well, who should you appoint as your trust protector? Often I see CPAs appointed. I often see professionals inside of a family, meaning somebody who has a professional training, a brother or sister. But really, you don't need a professional background. You don't need to be a lawyer or a CPA to do this. You need to take direction. And you need to follow what the documents say. And so it's the whole idea of the trust protector is amazing. And I mentioned it is a fiduciary, which means that they have a legal duty to act in the best interest of the trust and the beneficiaries. There's one more question about asset protection, and the question is what's better, domestic asset protection or offshore asset protection? And I love that question, because I had a good time debating that question in LA actually last month with a colleague of mine that he took the position, and we argued friendly for a while until I yelled at him. I'm kidding. That really the truest form of asset protection is only achieved outside of the United States. And I argued, well, maybe that's true, but it doesn't matter, because families don't want their assets anymore in Cook's Island, Bahamas, where it's expensive and sometimes hard to get at, and they like the flexibility of modern trust law. And really, at the end of the day, what is asset protection? It's a deterrent. And so what we're finding is, if the truest form of asset protection is to take all your money and put it in a paper bag and put it under the couch of in a bank in Cook's Island, that's fine. It's probably true. But there's a lot of disadvantages to that. And as I explained a moment ago, asset protection in the United States is compelling and it works. And we don't have any reason to believe that at the end of the road of litigation, those trusts are really hard to pierce. And that's the goal, right? Make them as hard as possible, so a plaintiff's attorney with an order against you says, I'm not going to spend $500,000 to get this judgment because I might not even get it in South Dakota or Nevada. But thank you for those questions. And there are a couple more, but we're kind of out of time. And I just want to say again to everybody who signed up, I saw some great names of friends of ours from around the country. What we're doing is special collectively in our industry. use the word again, virtuous. I'm wildly proud of it. I'm proud of Bridgeford. I'm proud to be connected to Mackay and Asbury. And I love the fact that we're back again where we started with a webinar series. So thank you all again for joining. Have a very happy and safe holiday season.